But we do get this coming out, and they're getting closer, folks. They're not quite right on, but they're close. Court rules COVID vaccine mandate for health workers null and void. Coming out of New York, Supreme Court, which last week struck down the COVID vaccine mandate for healthcare workers, holding the state's health department lacked the authority to impose the mandates. Now, they have a little bit different thing going on where apparently the legislature actually pulled that authority from them early on. So be careful not to extend what I've said too far into this. However, you see authorities required. You see the jurisdiction is required. You see in this story, and I'll only touch lightly, you can read it and see what the basics are. They talk about competency. Well, I talk about the jurisdiction. You don't have a jurisdiction, you don't have the competency. All right, so the words are a little bit altered here, but they are what I've been talking to you about. The court came in and said and ruled that the state's mandates were arbitrary and capricious on the basis of COVID-19 vaccines. Do not stop transmission of the virus, thereby eliminating any rational basis for such a policy. So what is that court talking to? Rational basis. Why would they even have a rational basis? Well, they're impliedly talking about this communicable disease code. This court doesn't say it. It just talks in legalese talk. COVID-19 vaccines do not stop transmission by local communicable disease law. Cannot be a vaccine. So in this story from the Children's Health Defense Network, their case, actually, they funded the money for this case. They showed that there is an arbitrary and capricious imposition. What they didn't show, and what this is the other problem you have to look at, this case did not actually attack what I've been saying you need to attack, which is their so-called competency didn't exist from the beginning. Whether it was the police power of the governor that did not demonstrate a non-fraudulent exigency for the emergency, or relative to the communicable disease code, which is specifically named here, it's a health emergency, that it was only presumptive and not determined, actually, and not determinable. So there's still some more position here that I want you to see. The very important lawsuit, nonetheless. They go and explain something here near the bottom of it. It's a real short story, a report. Moreover, it said the ruling may impact other similar cases nationwide, according to Gibson, who's one of the people who are responding to this. Quote, the judge struck down the mandate for two reasons. The first basis that the NYSDOH lacks authority to issue any vaccine mandates under the state constitution and state public health law is precedential, mostly in New York State. Second, the second basis, however, is applicable nationwide. That is, what is irrational, arbitrary, and capricious to mandate a vaccine that cannot stop people from getting infected and spreading COVID-19. Close quote. Now, I want to just point out, if you look carefully, this is a lack of full understanding of what's going on. Certainly, I can pick it up in the second. The national application is not through the federal court decision. It's because the local disease law, all local communicable disease law, require the rational, non-arbitrary and capricious treatment, mitigation of a demonstrated infectious agent. So, but the first one is in the same class. The lack of authority to mandate is what I've been talking more. They never did the 5 duties or so, 6, whatever it is in your state, in order to, on an individual basis, case by case, folks. This is what's supposed to be, not blanket either. Case by case, local communicable disease law required the local official to do things that were not done, so they never ever get to the point where we get to have competency. And in this case, if I haven't seen their evidence, you're going to look at it. What I would suggest is those of you going into the future, because I really don't think this is going away. This is the tack that they've taken. This is I told you, the most difficult way that the most difficult path of the society can defend itself on was this medical emergency thing. They went there, and so here we are. I think they're going to continue to push the bad road because they're not getting the right response. But your response would be, in the evidence that the vaccine, so-called whatever that treatment was, the injection did not prevent, I would do that as an alternative. If the court is to find that they have done the first duties of the official, in other words, determine non-fraudulent exigency, someone had it, they give all the due process. If the court determines that that has been done, in the alternative, we then say, and we offer this proof that these treatments don't prevent, as is required of the local health official to commit to. And so that it also is not stop transmission is another point. So do this treatment stuff in the alternative. And I'm only talking to those that are listening to me that may feel that this is something they need to prepare for in the future and be aware of, at least, and how to address this. Because you're still going to have some fallback lines. If this thing, because legislatures are changing the law to include the so-called pandemic, that private term of a foreign influencer, my concern is this thing's not going away, and you're going to have to be able to get around that part, because they'll just take this presumptive illness and run roughshod over everybody as this existential threat when it's not. The local law won't allow it. So great case as far as just the report of it. I don't want to undermine any of it because, again, you have your rights back there. You were shown to be, you lost your jobs wrong. In New York, you're going to have, those of you that want to go back into the field, you're going to have to, apparently this article says you have to reapply. This isn't a win for the workers, so to speak, but they get to reapply, and apparently you have a great need, so the odds of getting a job back may be good if that's what you want to go back into. Just offering a bit of that. But here we have the standards I was telling you about coming back from a court finally, even as misstepping as it might be, to show you there is standards. There is something that was supposed to be met, even if it's not as much as I would say you should press. We do see that a court can respond when given the proper case, or the more proper case, which hasn't been done. Up until this case, we haven't seen this kind of words. Well, yes, we did. Two words we did. Two cases we saw some of the words come back, but not in a full, they were admitting to the COVID-19 pandemic as being something. And that was the problem with those cases. Even here you see that they call them COVID-19 vaccines. They should not have been designated like that until they were shown to prevent. Then you could actually go, if the state wants to go there, then we're going to actually bring open that these are actually bioweapons, if your case is strong enough. And that the duty was on the duty of the official to arrest those that are offering a biotoxin as a mitigation measure. And so your state law then prevails, even you just press the federal. The state law, the federal can't interfere because this is a prerogative of the state court, the health issue. And then then you get to use those, the state would do this, would get to use those federal laws for showing that the exception's not met under Title 50 and that the Title 18 Bioterrorism Crimes Act comes into bear, and the state could probably pull that for. I say probably because I'm seeing there's just corruption through the judiciary.